Welcome to Common Forms of Immigration Relief for Family Groups and How to Screen for Them, sponsored by the ABA Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all the participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit it. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Emily McCabe. Emily is a senior staff attorney for the Family Group Legal Orientation Program in the American Bar Association's Commission on Immigration. And Emily, you may now proceed with the program.
Thank you so much, Donna. I'd like to briefly introduce the rest of today's panel. Joining me on the program are Sandy Restrepo and Vanessa Joseph. Sandy is an immigration attorney and co-founder of Colectiva Legal de Pueblo and represents individuals in various stages of the immigration process. And Vanessa is currently the City of North Miami's elected city clerk and serves as a supervising attorney for a notable nonprofit organization dedicated to the needs of South Florida's immigration population. And please feel free to read more about our fabulous panelists in the bios provided in the materials today. And before we turn it over, we are interested in tailoring our content today to our audience. So please respond to our 2 poll questions. The first poll question is, how many years have you been practicing immigration law? 0 to 1, 1 to 3, or 3 or more. Okay, I think we can go ahead and close that poll. Thank you everyone for answering. It looks like the majority have been practicing for 3 or more, so welcome. And the second poll question today is, what is your typical practice area? Civil, criminal, immigration, or other? Okay, and we published that poll. Wonderful. It looks like the vast majority come from an immigration background. So welcome to all of our seasoned immigration folks. And we can jump right into some of the discussion topics. The first thing we're going to cover today are general tips and best practices for screening family groups. And if I could just kick it off to Vanessa for what are some general best practices you've developed for screening family groups?
Absolutely. And first off, thank you so much to everyone who's joined us here. And of course, thank you to the ABA for this amazing webinar that we're about to have. My name is Vanessa Joseph, and I'm actually a supervising attorney at Catholic Legal Services based in Miami. And one of the things that we have to often deal with is family groups who are coming together, but family can mean so many different things to so many different people. And so what we've realized is the importance of making sure that we're able to determine, right, who is in this family group and how are they defining themselves as a family. For some folks, they're coming in, they're saying, this is my husband, this is my wife, and they are in fact not even married. For some folks, they are coming in and saying that, well, this is my son, this is my daughter, this is my child. And in fact, they never actually gave birth to that child. And so there were no adoptions that took place, really no formal mechanisms. And so for us, it's extremely important to try and first suss out what this family dynamic actually really is. And so oftentimes, especially if there aren't really young children involved, we're very comfortable at the very outset dividing everyone as their own individual person and individual intake, and having full on conversations with that individual to kind of determine what their personal needs are, what their personal goals are as it relates to immigration, and then try to, in a not so obvious way, try to determine who this family relationship who exists in this family relationship. And one of the things that we find extremely important to do is make sure we separate folks at the outset, because it could be a little startling to individuals if you're starting to divide them once they've already sat down in your office together as a group. So lucky for me, my office is small in our downtown office. I used to have a really big office in our Broward location, and it was easy to say, oh, well, there's no space in our downtown office. That's super easy. But if it was in the Broward office, I'd really have no excuse for that. So in our downtown office, I'm able to say, hey, actually, I don't have that much room for too many people, so I'm going to take you one by one, if you don't mind. And so the reason I like to do that is, again, because I want to make sure that I know who is in this familiar relationship. And then I try not to go into questions about other people. I try not to go into too much detail at the very outset about anyone else in the family, because I don't want to hint anyone off. Sometimes you're able to determine that there is some kind of abusive relationship that may exist. You may see that it's easier to tell that there is some kind of dominance, right, between some of the folks that are coming in. And so I don't want to tip anyone off too early, and I just have just the generic intake that I typically would. And so for me, that's usually how it works. It just as a on a broad basis, and that what I found to be extremely helpful in my practice. And I think over time, especially for those of you who are more seasoned, who've been doing immigration for 3 or more years, you'll find that as you go, you get to know a lot better who your population is, who's coming into the office, and start to have like a much better idea about what best practices could work for you.
Great. Thank you. Sandy, anything to add?
Yeah, sure. As was mentioned, my name is Sandy Restrepo. I'm with Colectiva Legal, and I am an immigration attorney. I've been practicing here in Seattle for 10 years. And also thank you to the ABA and to everyone else for being here today. Um, I would also like to mention, even before starting the consultation, if we're doing a clinic setting where we're going to have a lot of folks in one space, we make sure that we confirm that they know where our office is located, if they need any help with directions or transportation. A lot of folks are newly arriving into the country. They may not have a license, so our organization does have a vehicle that we were able to get from the city of Seattle, and so we're able to help with transportation. And also, usually folks come, as Vanessa mentioned, in a whole family setting, so we try to have childcare available or activities for the kids. We tend to see when adults start talking, the kids start playing, so we have an area for kids to play or activities. And we also provide beverages, light snacks. Sometimes if we're doing an all-day clinic, folks can be there for a very long time. So we want to make sure that they feel comfortable, and also doing it at a time that's reasonable for them. So if it's after work hours, after school hours, our goal is to try to be as accessible as possible. and also to try to make the environment as comfortable as possible. So even before they sit down in the chair, we want to offer them coffee or water and make sure that they're feeling as comfortable and try to create a warm environment.
That's great. Thank you. And you already touched on this a bit. I love the idea of having light snacks for folks too. Any other in-person screening tips you wanted to share?
Sure. So in terms of in-person screening, it's also very important to start the conversation. I always introduce myself, and I always, even before I ask them any questions, let them know that what we're going to talk about is confidential, that even the folks that they came in with, they can share what they talk about, but um, I'm not able to share with anyone else if anyone asks any questions about what was discussed. And so we make sure to do that. And then in terms of the office space too, I tend to make sure there's enough chairs for everybody, that they're comfortable chairs. We used to have, when we first started off, like folding chairs. And so if we do have a lot of folks, we want to make sure they're comfortable. So try to have, as many of the nicer chairs available as possible. I have a couch in my office too, so sometimes the kids just will, sit there. And so in person, just setting up the environment as much as possible, and also in terms of making eye contact. I know sometimes as attorneys, we're kind of like, go, 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 go. And sometimes we just need to slow down. If I do need to take notes, I tell them how I'm going to be taking notes, that I'm going to either be, pen and pad or on the computer. And that if I'm looking away, it's not that I'm not listening, but that I'm actually just jotting things down so I don't forget later. And then in person too, usually if it's a clinic setting, we try to minimize the amount of time. So being aware of time, because sometimes depending on the person that you're talking to, they can either it'll be hard for them to start talking and to start developing that trust, or they have a lot to say. And so I, at the very onset, also tell them we have 15-20 minutes and we're going to be aware of time. If we have a lot of staff that day, I will have someone also help me keep time or remind me, hey, we need to wrap this up too. And so it's just important for them to open up, but also knowing that we have parameters and just limited capacity, that we can't discuss their case for too long. And then also, if we're in person, I usually want them to walk away with something, either if it's an info sheet or my business card or some way that we have follow-up steps afterwards, so they know that if we're going to take their case or if we have local resources. And I think we'll talk about more about the trauma informed pieces a little bit later, but making sure that they're walking away with some information in very clear terms, speak very slowly, in Spanish. Most of our client base is in Spanish, so we try to make sure that they understand everything, and then leave time for questions that they may have that arise after we discuss what the possible forms of relief are for them.
Wonderful. Thank you, Vanessa. Anything to add?
Sure. I think what I can try to do is really cover maybe the remote piece, right? And I think over time, remote has come to mean something completely different than what it used to mean in the past. And I remember in the past when we would talk about doing something remote, we would be talking about going to maybe rural parts of the Tri-County area in Florida, in South Florida, where I'm based, and we'd maybe be at Immokalee or Belle Glades, and that would be something that is remote. And so the dynamics were different because, as Sandy said, you could be in a clinic setting and there are a lot of people around. If you're not able to get a space that has breakout rooms or smaller rooms where you're able to see someone individually, you may be in a situation where an entire family group is being seen at the same time by different attorneys, and maybe you don't want for some of that information to be shared. But now remote has taken on a completely different context, and that context is actually online screenings. I know that in Miami, I ended up having to do during the onset of the pandemic in 2020 was provide remote legal services to folks using only Zoom. And it was hard for a lot of people to get onto the technology. And so folks are having to be really creative about how they do that. Are they going to a web cafe? Are they going to a friend's house, a family member's house? Are they having to rely on someone else in the household to help them access the internet and other technology that's necessary to communicate with us? And so in doing that, what we realize is that we have to add on some time to our screenings because we want to make sure that that person is actually in a safe space. Just because that person was able to access technology, more or less easily, that doesn't mean that that is yet a safe place for them. And so it was really important to start off the conversation asking maybe more, I would say, introductory questions, asking about how the weather is, asking questions to try to determine, is there someone else in this room that is within earshot, or is someone who is going to try to be an active participant in this? And so in those first maybe 5 to 10 minutes, we could suss that out, right? And we would tell people, look, we'd love for you to be in a quiet room. We'd love for you to be by yourself because we want to be able to hear you and only you. And if you have folks talking to you, it can get really distracting. And so making sure that you're articulating what your own needs are, right, as the practitioner, as the attorney, and making sure that those needs are actually needs that will isolate the individual and allow them an opportunity to be fully transparent and honest, I think is extremely important. It was really hard to get folks at the very onset to understand how to use it. So we would make sure that we had navigators available to call folks and teach them how to get onto the technology. Here are the steps. We're going to text you the link. You're going to click on the link. You're going to click these buttons. And we had great success with that. And we also had great success in making sure that we were able to minimize as much as possible interference by other folks who just didn't need to be part of the conversation. It's not to say that there is anything, wrong with the individuals who were in their household, but it was just more so wanting to make sure that we not only, as Sandy mentioned, protected confidentiality, right? But we also just wanted to make sure that that person who we were trying to see, who we are trying to serve, felt comfortable to share their entire story, because you already have this barrier that they're not used to, which is technology. You're behind a camera, so are they. And that could be difficult for folks. It could be a situation where they want to trust you. And so you have to produce as much contextual, I guess, an environment that would allow them to trust you, even when you're not able to build that rapport face to face.
That's wonderful. That's great. And Sandy, how often do ethical considerations arise in family group intakes? And kind of as the practitioner in a panic state, I imagine when you realize what's happening, what do you do? And I know we could do a whole hour on ethical considerations, but just wondering what your thoughts are.
Yeah, I think as Vanessa mentioned too, when we first see a family group, we try to suss out relationships and then also do separate intakes, just because we want to be able to identify individual forms of relief, and then we say we can circle back. But I've been in situations where, let's say, a couple comes in and they're very adamant about being together during an interview, but if we start to see, either if it's in body language or some suggestion that there may be some kind of situation where there is DV, or um, sometimes it's not even spoken, it's just in terms of like body language or comments that are made. Usually what I'll do in that situation is take a break. Either, I go get some materials or something like that. And then what I say is that for the next part of the interview, we're going to do some individual questioning, and that's just for my own sake. And then once we do separate folks, I will tend to, if I think someone is in danger, talk to them first and let them know, remind them of the confidentiality piece, and also that whatever is said will not be not only not repeated to that person, but also will not leave the room. In terms of, there's also concern with police and immigration being involved. So those kinds of like reporting situations, I tell them I'm just asking questions just to be able to better understand their case and give them any kind of form of relief. And so I'll go through asking them, do they feel safe at home? If they've ever had any situations where there's been any types of violence. And in terms of this also being a piece of trauma informed, I don't ask them for too much detail because I don't want to traumatize them right here in the office. And the potential, if that abuser is in the same space too, they may know and be tipped off that we're having this conversation. So what I tend to ask is just if they feel safe, or if there's ever any forms of abuse. And abuse doesn't always have to be physical abuse. That's always like the first go-to when we think of domestic violence. But as many of you know, it can be emotional abuse, financial, or if the person that is with them is a U.S. citizen, there can also be threats of calling immigration on them, or using their lack of legal status as a weapon in terms of the power dynamic in the relationship. So I tell them, and sometimes I may not get a clear answer, but I tell them that we can also talk about it at another time if they want to set a different time to come. But usually, if we're able to get any information, I don't give them any pamphlets. I don't recommend that in terms of like DV, because if they come home and their abuser sees that, that can also have repercussions. And I'm not going to, call the police at that moment either. And so for us, it's just important to identify that, flag that. I flag that we have our client database system, and we want to make sure that there's not conflicts. So being very aware of that and noting that in our own internal uh, database, but not necessarily making a big deal about it at that point, because in real time they could be at risk if we do. And so we'll talk about potential forms of relief later on in terms of what we can do to support them. But if we're having a big event, we usually, at our organization, we do have a community advocate and other folks that can follow up with them later when it's safer to do so. But we want to at least try to make a plan so that we can, if we do have the capacity to take them on as a client, that we can later figure out what forms of relief they're available for. And also, if there are kids, and let's say you don't have childcare that day and the kids are in the room, even if it's a 1 or 2-year-old, I won't go into questions because they can tell when mom or dad is stressed out or is emotional. So I don't also want to activate the child, because by proxy they're also going to get impacted. So I make a note of it, very, very surface level. If it's the very first interaction, part of trauma informed care too is that we don't want to re-traumatize them. So talking about something like this can be very, very, very emotional for someone and re-traumatizing them. So we want to make sure that that's not the experience that day. If it's the first encounter, that we want to note that, and there could be plenty of time to get into that in further detail if we do end up taking on the case. And if we refer it out, we also mention that in a very brief way if we're doing a handoff to another community organization or another attorney. But just making sure that we're honoring their own experience and that we're not re-traumatizing them in the moment. And I know as an immigration attorney, we can, the ironic part is something so horrible can actually mean some kind of benefit for them in the future. But we want to make sure, I've seen, and sometimes attorneys will get excited, oh, this is great, not for you but for your case, and just how you say that is also very, very important. I know that a lot of we joke about it, I think, internally as immigration attorneys, but we also want to make sure that we're not tone deaf to that, and that we're also just not making light of it, because I do sense that sometimes that happens, even if we don't mean any harm by it. That's not our intent, but the impact can be. So I just want to make sure that as attorneys we are aware of that we might be thinking in our head, this is great, we have some form of relief, but just not saying that in those ways to someone, because that impact of that can be very severe.
Yeah, I agree. I think that's a wonderful thing to just keep in mind. Vanessa, anything to add for ethical considerations?
Absolutely. And I really appreciate what Sandy just said, because oftentimes we as attorneys are thinking about the end goal. And especially if you've been doing this for long enough. I mean, I know I've been doing it for, it's going to be maybe 8 years this year, which is not a long time, right, in the grand scheme. But I've been doing it long enough that I may hear a story and I'm only looking to listen because I'm trying to get to an end result. I'm trying to get relief for this person. And so I have to constantly be checking myself to make sure that I'm not like, my eyes don't light up, right, when I hear some of these horrific stories, because some of these horrific stories could ultimately lead to a benefit, right, that can help this individual get out of whatever situation that they're in right now. And I can maybe already be thinking of the resources that they have accessible to them as a result of what they have been through. But we have to understand that for this person, this was an extremely traumatic event. And oftentimes we're not able to think about that because we've been doing this for so long that, trauma is something that, we've gone through secondary trauma for the first few years of practicing. And then there's a point that we got to where we said, you know what, there's actually nothing I can do about this situation but try to help the individual. And so I'm just going to, continue on because that is what my ultimate goal is. Not realizing and then having them share that story however many times could be extremely detrimental to their own personal well-being. And we have a duty to care about that just as much as we care about the end result and the relief that they're trying to pursue. And so when we think about some of these ethical considerations, number one, especially in a group setting, I really don't even want to hear the story, right? Because you could cry in front of me. You could become very anxious in front of me. Your body may have physiological responses that I may not be equipped to handle in this time, and we are probably not set up to handle in this time. But if I do hear something that piques my interest, actually, this is something we need to flag and revisit later with this person. However, we schedule that next follow up, then that's what we have to do. Oftentimes I can kind of determine, on our intake, we ask things like, is this a safe address? And safe could mean two things. Is it safe to receive mail here? Or is this where you actually feel safe? And so we have to know, do we mark this address as safe and unsafe? Because if we want to have a follow-up, well, maybe we can't send a letter to your home requesting that you come visit us for a second interview. Maybe we have to find another way to get in touch with you because even the number that you gave us may not be safe, or you're picking up that number in a household that is not safe. And so if we get too much out of you at the first interview, right, you may end up disclosing that you discussed this with the attorney. And so your abuser might already be clued in, you know what, at the next call, they might go deeper. And so sometimes I like to just acknowledge that I heard it and then talk about the fact that we're going to follow up because this is actually not the right space or place for this. Another thing that I think is really important when we talk about these ethical considerations and how we're dealing with some of these stories, we have to be very, very transparent about the fact that some of us have not suffered some of these things. And we have to be able to comfort our client or the individual who's before us and let them know that, look, I don't want to re-traumatize you, but there are some things that we need to discuss in order to be able to assist you. You can guide me on how we do that. You can give me the information as to how far I can take you in this one session. You can tell me when to stop. You can tell me if this is becoming too much for you to handle in this session. But we have to understand that we can't lead in that way. And a lot of times too, we also tend to make determinations about whether a story is credible or not based on what we believe can happen. And I think this goes into, when we talk about cultural competence and cultural humility, which are two different things, right? One is ongoing. Cultural competence is a destination, but cultural humility is an ever evolving process of making sure that we're doing some self-reflection to determine, am I applying my own biases in this situation? And I know that in this political climate, folks don't even want to talk about these types of things, but we have to in the work that we do, because what ends up happening is that we hear a story and we're like, you know what, that could never happen. I often think about an example that I was told when I started to practice law at my organization, and they were talking about a story where the judge believed one person's story over another because of how the person described their escape. One said that they went under the bed, and the other said that they ran into a closet. Well, those things aren't the same for us, right? So, whereas we can run under a bed in Haiti, we can't run into a closet because we don't have closets in some homes, right? And so when a judge heard it, one sounded more believable because of where Haitians will tell you that they jumped from one roof to another. Yeah, I can't do it in Miami, but I could totally do it if I was in Haiti, depending on the architecture of the home. And so these are the things that we need to be checking ourselves on. We can ask for more information. There's nothing wrong with saying, can you describe to me what this neighborhood looks like? How are the houses leveled? What does the interior of the home look like? And actually add these things into your filing to describe, right, how this person could have done all of these things that don't seem plausible. But it is not up to us to just say automatically, actually, that doesn't even make sense. We need to be asking questions. We need to be taking time to understand where this person is coming from, why this type of abuse could be so damaging to the individual. Folks don't always have to show their feelings. Sometimes people have suffered so much that they actually could be numb. And we have to respect that. We can't automatically assume that because we would have reacted this way. It's my favorite when women talk about what they would have done if they were in an abusive situation. Until you get in the abusive situation. And so we can't do that to our clients because that's damaging to them. And so those are the things that I think, as it relates to the ethical considerations and, the cultural humility, we have a duty as attorneys or as legal service providers to make sure that we're being mindful about how we're coming into this conversation. Are we coming in with this lens of curiosity and wanting to understand, or are we coming in with this predetermined notion of how this story is going to go and how it should go?
That's wonderful. Thank you for all that great information. And um, how, uh, Sandy, you had mentioned earlier about trauma-informed care. Can you just explain a little bit more about what trauma-informed care is and whether or not it's important in immigration work?
Sure. So trauma-informed care is looking holistically at your client into understanding that the day that they're stepping into your office and coming to you, there's probably been a lifetime of different experiences that they have gone through, and that can impact how they're showing up and also how they're explaining things. And I think Vanessa made a great point about also um, sometimes the clients may not even understand or digest as what has happened to them as trauma because they can be numb to it, or they cannot even remember some of that. So ultimately, as attorneys, and especially a majority of the folks that they've been practicing for 3 or more years, we also want to make sure that in our own practice, if and usually most of us do have limited resources and limited capacity in immigration, but that we're able to at least have some part of our own practice where we can refer out to community resources or to different aspects of the care that they're going to need to be able to have them show up in a as healthy as they can be, and being able to tell their story from a place of strength, and knowing that, you know, whether they have a asylum interview at USCIS or they're going to be in front of an immigration judge, one, hopefully we have enough time to prepare them and to make sure that they're receiving proper counseling, at the very least having some form of evaluation with a mental health counselor, and also other resources that they're able to tap into that they can trust to be able to navigate. There's a lot of food insecurity that's happening here locally, at least with in our area, and probably in other parts of the country as well, and different sorts of access to either employment or childcare. For us, it's very important to understand that our client is not going to be at their best and be able to even bring us the evidence that we need for the case if they don't have a safe space to live, and if they don't have any resources to be able to even, you know, get a copy of a birth certificate or a letter of support. So um, our work as immigration attorneys is very heavy, just even looking at the casework. And we're not, you know, I'm not suggesting that we are caseworkers or social workers at all, but that we at least know where to point them in the direction that they can access some of these services, because if not, that's also going to hinder us in the long run in terms of their own building up their own case. So when we've been able to navigate either referring them to a food bank or referring them to a mental health counselor, at least even for a check-in, or sometimes we've been able to get um, psychologists or mental health counselors to come in while we're doing our intakes and just have a quick check-in and talk about why breathing is important, what different self-care techniques that aren't going to cost them money. And so we're able to have those folks on site just to have a quick check-in with them and let them know if they need to. Mental health is such a taboo subject and trauma within a lot of immigrant communities, so it's important that they're understanding. And my kind of roundabout way with that is just saying, like, this is going to be really great for your case if we have an asylum case, a cancellation, or any other sort of form of relief. If the judge or the adjudicator sees that you are making attempts to heal this trauma, then that's going to be very beneficial for the case. So sometimes that can be a way that, okay, I'm not doing this because, you know, I'm weak or I need help, which is usually the stigma attached, but this is for my case. And so usually that will really, really help break down a lot of those barriers, that if they know that the end result hopefully will be the same, where they're able to talk about things and get to a healthier place mentally for themselves and their families, but also if they see that this is going to have a benefit. And so we have lots of resources where, and sometimes those agencies are also, you know, at capacity, but they can triage and see, you know, if there's any support that they can lend. But we want to at least leave them with some form of support so that they know that they're not alone through the whole process. And also when and we'll talk about this a little later, but when we're preparing them either for an interview at USCIS or with the immigration judge, we want them to go in being very fully prepared into what to expect. I think in my earlier days as an immigration attorney, I was very blindsided or caught off guard with the demeanor of immigration judges, the demeanor of ICE attorneys, at sometimes where they're very cold and very matter of fact when you're dealing with very difficult traumatic situations. So my job has always been to make sure that there's no surprises. I want to prepare for all elements, and I don't even know what mood the judge is going to be the day that we go in. They could be a very great, you know, understanding and fair judge, but they could have had a rough morning or not had breakfast or anything like that. And so we want to make sure that the client is prepared for that, and that they know that their trauma is probably going to be minimized that day. They're going to be tried to be discredited, and opposing counsel may want to poke holes in their story. So part of when we take on the case is looking at that and making sure that they're prepared every step of the way. That's what we can be doing as their advocate.
And if I could add to that, you know, when it's so easy for us with our logical minds to say, oh, now this person must be lying because their story has quote unquote changed. right? From the first day that we saw them to the last day of court prep into the courtroom. What we often forget is that the client has actually built rapport with us throughout this situation, right? So that's one perspective that I always have. You know, our relationship has grown. They've seen that I'm not here to harm them, and so they can be a little bit more open with me. But what also happens is the fact that we sometimes are so traumatized by something that we actually forget details, or the situation was one that was so difficult for us that we may forget certain details and leave it out. And in a moment of anxiety, a moment of stress, we completely forget to mention it in court, right? Which is why as close to, as close as you can get to a mock with your client, the better, right? Because they're already in this stressful situation. You've already pulled 3, 4 people from your office who they have no idea who they are. I like to pull people from different floors that have never met my client, that can sit in and pretend to be the judge and the interpreter, opposing counsel, and the like, because that you want to make sure that that person's comfortable. But it's always, funny to me how us as the legal service providers, you'll have folks who will say, oh no, this person's lying, I can't take the case, I have doubt, I have this, I have that, knowing good and full well that you were in an argument yesterday and you totally forgot certain things from that. You forgot what you did in that argument, right? You forgot what you said, you forgot how you behaved, but you're ready to pounce and either like drop a case, fire a client because they forgot a detail. And we have to be really careful with that. And so to me, it always helps to try and get an expert, especially if I know my client has been through a lot, to get an expert who's able to talk about, right, why this may happen. Because we don't know that it's going to happen, but if it does happen, then we actually have some understanding of why. And it's one of those things that I try to keep in a resource bank. Reasons that stories may differ, some details may shift. Now, obviously, we're not talking about someone who's from one country and then completely, the story is completely different. I mean, not a single detail remains similar or the same. But there are instances where people can absolutely want to take on a whole other persona or personality and completely leave out a detail. So we have to be mindful of those things, and we have to be mindful of the fact that this happens, and how do we help our client as much as possible to ensure that that's not detrimental in their case.
Thank you so much. That was great information. And thank you both for explaining cultural humility and trauma-informed care with such great examples and with such great information. So now we're going to turn it over to look at a few common forms of relief and relief-specific tips for screenings. And how we have it split up is kind of 2 realms: the defensive cases / removal proceedings, and not necessarily just for defensive or removal cases, but often, and then affirmative cases. So first, if Vanessa, you could tell us a little bit about asylum and withholding of removal.
Absolutely. So the good thing for us is that we have a lot of folks who've been practicing immigration for 3 or more years. So you're probably familiar with asylum. So I won't go into too much detail because I know that even just setting up this part of the conversation, we've spent quite a great deal of time, and I want to make sure we leave time for questions. But essentially, someone is here in the US and they're saying that they're afraid to go back to their home country because they have been persecuted or they have a fear of future persecution. Now, when you look at asylum law does not say that it is more likely than not, right? That's a withholding standard. We just want, a little bit. We just need a little bit. But the way that we set up these cases when we go to court, my Lord, the judge wants to know, that this person is 100% going to touch down. And the moment they touch down, that it's a wrap for them. And that's unfortunate, right? Because that's not we've come to. And so I say that, not to be funny, but in all seriousness, it is something that we absolutely have to include in our arguments, that you asking for way too much, but I'm gonna give it to you anyway, right? So, when it comes to screening for asylum, I personally believe that asylum, just like many other forms of relief, can carry with it significant amounts of trauma in the story. And so, like I said before, it's extremely important to kind of get some initial facts in the beginning and try to determine, is that one of those stories or cases that we want to handle with an extreme level of care because of the type of trauma that they suffered? Or is it one, I mean, when we're treating everything with care, but or is it one that we will more or less be able to navigate this safely with the person in that setting? And the setting that I'm typically talking about are those clinic settings, those immigration screening settings where you don't know who's coming up to you, right? Because the thing is that if you are able with someone at a large event, I mean, I don't know for you, Sandy, but I know that for us locally, we want to make sure that we can do as much as possible if we can at that moment, and then give the person as much follow-up details as they will need, right? And so I want to be able to try to get through as much of it as I can with you, in hopes that our next meeting will be bringing me documents, will be coming with your statement in your native language, or maybe the biographical parts of the form, providing me with those answers, something that requires less, intensive work, right? Because we were able to more or less navigate the story. For as far as the screening for those, I think that what's really important to me is helping the person understand what asylum law really is. So in my quick background, it's not as simple as that, right? Because persecution has to be based on a specific set of categories. And oftentimes, depending on where your client is from, political asylum is a thing. And we know that asylum is asylum, and then there's political opinion as a basis for the persecution, right? And so wanting to make sure that they have that education, because you were in a situation where your family was trying to kill you for your land. Well, okay, how do we articulate that into one of these? Is that a ground that we can actually pursue? Number one. If it is one of those rare stories where it's not as clear cut as political opinion may be, or an assumed political opinion, right? Because you can not have a political opinion, and based on where you're from, that is a political opinion. And so you may run into some clients who say, well, no, I never had a political opinion, and I never joined an organization, I never joined a political party, not realizing that maybe where they're from, that is actually taking a bold stance, right? And as far as it relates to political opinion. But where it's not race and nationality, and it's not as clear cut, you want to make sure that that person has an understanding of why you're asking certain questions to arrive at one of those bases of persecution. I think another thing that sometimes folks may miss is the fact that, especially with from depending on certain countries, it'll be an unidentified individual, unidentified number, unidentified this, unidentified that, and that's for the persecutor. And we're not even talking about what makes you identifiable, right? How do they come to know you? So there are a lot of like little details that we sometimes don't think to ask, but we actually do want to have a basis of knowledge for, because we have to add all of that into the asylum case. And I'll say that when it comes to asylum, making sure that we have enough support to back up some of these claims. I think sometimes we think about it as, and yes, right? In theory, it should be sufficient to have our client's testimony. But then you get to court, and maybe it's different where y'all are from, but I know in Miami they want to see the whole thing, and it's like, oh yeah, for sure, that makes sense that my client would be running for their lives and remembered to go get their membership card for the political party. Yes, you're right. I'm gonna go get it. And so, you want to make sure you have as much detail as possible, have an understanding of what's happening in country that could make it difficult to that. So just really making sure that you're being thorough, I think, in asylum claims is extremely important, just as is with everything else, but especially in asylum. And then also wanting to know what they did after they left their country, because firm resettlement is and can be a very big issue depending on where your client's coming from. So I'll stop there.
Sandy, anything to add to asylum?
I would just agree with Vanessa that here in Seattle, it's the same standard. I think the judges are, have the same playbook where, you need to show um, police reports, a lot of evidence. And so I think that in my earlier days as a bright-eyed, optimistic attorney, I thought that their word was going to be enough, that their, story was compelling, and that anyone would see that they have suffered past persecution and had a fear of future harm. So, we were going to win. But ultimately, as y'all know, in immigration court, that's not the case. So I try to be as honest as possible on the onset when I'm evaluating and screening for common forms of relief, and tell them that, the likelihood that they'll win their case, we pull up either like the track record from Syracuse University has great data on judge by judge and city by city what the approval rates are for asylum. So I want them to know and go in very, very aware and just feet on the ground as to what is the probability that they'll win, because it is very very disheartening for them to think and to hear from us as a professional that we think that they have a great case, and then all of a sudden they get to court and that's not the intended outcome. So trying to be um, as still as optimistic but also as realistic as possible given the climate and just the requirements for asylum cases to be won. Should I
Thank
jump
you.
into the
Um,
other?
yeah, go ahead. Hmm.
Oh, okay, so I am going to talk a little bit about cancellation of removal. And so there's been so many changes recently with Ms. Chavez and with the stop time rule. I do want to mention that before going into the general requirements, that if you are screening for somebody and let's say they had a defective NTA issued and you want to invoke, the stop time rule and see if they can qualify now because they have a qualifying relative and they've accrued enough presence here in the US, I encourage you to try to do that and reach out to whoever is the local TA or ICE attorney that is assigned to the case, and just say, we have, if you're able to get the NTA, because usually, folks may or may not have access to that. And then just to take another step back, sometimes we may not have these answers when we're doing the first screening, but if we need to FOIA and get that information, I always suggest, you want to FOIA everything, get FBI background checks, no matter if, they may have not had contact with any immigration or any government agency, but just you gotta be prepared for everything. So FOIA and FBI, if you're gonna take on the case, or even if you're just screening the case, I would say sometimes we do have even clinics where we're helping folks fill out the FOIA and the FBI, and we sometimes roll our own fingerprints here if we have the capacity in our organization, or refer them out to professionals to do that. But those are just very important things to be able to thoroughly assess if you're able to take this case or what forms of relief they have. And so if you come across someone that does have, let's say they were NTA'd, I've had a client, for example, that was NTA'd in 2005 and their removal proceedings started in 2014 maybe, so they had 9 years, but it was a defective NTA, and they're going to have court, and the dockets are very, very backlogged in immigration court. So let's say they haven't had their final court, and for some reason they didn't have an attorney, they were not able to file a cancellation of removal application previously. That's something that can be brought up. I recently did this with a client of mine, and we were successful to be able to evoke, the stop time rule and say that they were now eligible. They had U.S. citizen children, and were able to apply. So with cancellation of removal, the first thing is the 10-year presence they have to show, and that can be very difficult. Of course, they're probably not going to come to your first meeting with 10 years of immaculate records of being here in the US, but that's something that, you want to give them a checklist, be as creative as possible. There's different ways from, tax returns to leases to library cards to, Facebook posts or whatever you can show that they've been medical records, school records to show that they've been in the US continuously for 10 years. Depending on the judge, they may want month by month. I've had that situation come when they need to show the continuous presence, or some judges could be okay with one document for every year. It really depends. It's really good to know your local immigration courts, and within the immigration courts what each judge needs. And then also the other part is good moral character. So you want to screen for any contact with police, with immigration. It's always good in these situations to have at least your local state background check available for you while you're talking to the clients, to see if you can run at least local background checks while they're in the office with you. And then also another requirement is the hardship requirement, where they have to show that they've suffered exceptional and extremely unusual hardship. And I will say this hardship is it is very difficult to be able to prove that. Um, it's really, really challenging. I would say in my cases, we've had clients with children that have congenital heart disease and cancer, and copious records, medical records, and the judges say, well, that's just, how it goes. Or we've had therapists that also say, well, if they're separated from their children, it would amount to a death in the family, and it would, the emotional impact. And judges say, well, deaths happen every day, that's too bad. So you really want to know your audience, want to know your judge, and also be very realistic with the client. And if you do feel like you have a strong case, to try to take it as far as you can with all the evidence that you're able to gather with expert testimony. Usually a psych evaluation is really, really important. Letters of support are very, very important. So just getting your client ready, even at the onset, to say, we're going to have an uphill battle, but we're going to need to document as much as possible. And apart from cancellation of removal, another very possible but not ideal outcome can also be prosecutorial discretion or admin closure. So if that's something, now with without the Doyle and Mayorkas memos that we're able to kind of rest upon, you are really at the hands of the local ICE attorneys to see if they're willing to admin close or try to do a joint motion with you. And so I always talk to my clients about that. We have a handout that we give them where we show them, this is what admin closure is and this is what a dismissal is, and we want to be able to explain that, especially with the work permit. That's the biggest difference that we see. If we are able to admin close a case, then they can keep their work permit. If we do a case dismissal, they lose the ability to renew that work permit. So that can be the livelihood of somebody in the US if they don't have their work permit anymore. So that's something that's just very, very important to keep in mind. But we're seeing a lot of success in the court with getting case dismissals and admin closure if there's also another form of relief. And I know we're going to get to that in a little bit as well. So cancellation of removal, I'll wrap that up in PD, because those are very, very important forms of relief, that if you can dismiss the case and get rid of the removal proceedings completely, that's a very viable and a win, I believe, in most situations.
Great, thank you so much. And now we're going to turn to more affirmative or affirmative-ish cases. And the first one we're going to talk about is Special Immigrant Juvenile Status, or SIJS. And I'm actually going to take this one. Before I was at the ABA, I was at a local DC nonprofit, and I did a lot. I did almost exclusively SIJS cases in Virginia. So I know a thing or two in the Virginia eyes for SIJS. And because there are so many immigration pros here, I'm not going to bog us too much in the details of a background on SIJS. As most of you probably already know, it's a 3-step process, a bit different than most other forms of immigration relief, because you start in the state court. And you have to finish in state court before you can even move on to the USCIS part. And one important thing to note for SIJS is in immigration law, a child is someone under the age of 21. But because SIJS is so state court based, it depends on your court's jurisdiction, what they say is a child. And for many states, that is somebody who's under 18. So just knowing where your state is would be one of the first steps. And SIJS is very state specific. For example, death can mean abandonment. A death of a parent can mean abandonment in some states, and it does not mean abandonment in others. So just knowing a little bit of your state's views on abuse, abandonment, and neglect is going to be very helpful before you start diving into these cases. And the SIJS in general is for children who were abused, abandoned, or neglected by one or both parents, and it is not in their best interest to return to their home country. Again, before they can actually go on to the USCIS portion, step 2, step 1 is to get a predicate order from the state court that has the necessary language. And it's also important to note that if you're in situations where you're coming in with a child, the mom and the dad, even if there was prior abuse, abandonment, or neglect, that child is probably not going to qualify for SIJS because the reunification prong has been met. So just to, you don't have to delve into all of these topics with somebody if they're living with both parents to this degree in an intake, in the initial intake. In my experience, explaining why you are going to ask a bunch of tough questions to the children is always very helpful. Even if you think they're too young to understand, kids are a lot smarter than a lot of folks give them credit for, and catch on a lot quicker. So it helps give a little bit of control to younger kids and to older kids, and it also shows respect for older children, in my experience, which in turn helps build rapport and makes them feel a bit more comfortable in opening up to some of these really, really difficult topics. And just as Sandy and Vanessa had mentioned, separating out the kids from the caregivers who brought them there is very important for SIJS. A lot of children did not tried to sugarcoat their lives to the caregivers in the US, and so they might not know the extent of what the child suffered in home country. That was not uncommon in my experience. So they might not feel comfortable disclosing a bunch of information that is not only difficult to talk about, but difficult for the other person to hear, especially for children who have suffered trauma. And of course, there are times where the caregiver will not feel comfortable with you talking to the child alone, and that's fine. I just tried to set a lot of ground rules in those situations of, okay, I'm going to talk directly to the child, and I only want the child to answer. So that way, again, just trying to make it as one-on-one as possible, and to try not have too much interference from the caregivers. And also, regardless of the age of the child, keeping the questions simple and open-ended tended to have better results for me. For example, asking the child, have you ever been abused, abandoned, or neglected by your parent, is probably not going to get you very far. And I would usually ask with a very open question, such as, how was your life in home country? And then from there, build such as build on what they're saying, and also taking it one element at a time: abuse, abandonment, and neglect. For example, who did you live with can lead into, okay, well, where was your mom? Where was your dad? Do you talk to your dad regularly? It can really identify potential abandonment claims. And another example, did you have enough clothes and food at home? What happened when you felt sick? Did anybody take you to the doctor? Those can help identify potential neglect claims. And for abuse, being oftentimes not using euphemisms was helpful. Did anyone in your house ever hit you? Did anyone in your house ever call you names or was very mean to you? May identify potential abuse claims in my experience. And then when it came to school and work, as Vanessa explained with cultural humility, our or my view as somebody who grew up in the US, my view of school and work are very different institutions, and only when I was done with school would then I be able, when I was old enough, I would maybe get a job. And so that just can be very, very different depending on the populations you work with. And the whole view can be very different. So recognizing that and making sure that your questions reflect a non-judgmental and open to whatever they might say type of conversation. So asking for specifics also seemed to help in my experience. For example, starting with, did you attend school? And then following up with, okay, did you attend school until you left for the United States? And why did you stop going to school? And similarly with work, did you work? Okay, did you help caregiver at work? Those were often two very different responses. And just again recognizing that their concept of school and work might not be as black and white as ours or as mine was. And if it looks like the child may be eligible for SIJS, I explain the process, and I am clear about the very long timeline of SIJS cases, no matter the age of the child. Again, even if I'm dealing with a young child, I had no problem repeating myself every time we met about my spiel again about SIJS. That's just par for the course. You know, we're in this every single day, and many of our clients, it's going to take a while for them to be like, oh, okay, yes, this is part of my case, and this is just part of the process. And so just recognizing that and being like, okay, sure, let's talk about it again. And again, even very young children, in my experience, benefited from being in on the process and in on the plan. And it really only helped my clients open up to me more, which led to, in my experience, better representation. And of course, as with all client work, try to end on a happy note. With kids, I found it always pretty easy because you could ask, hey, are you in school? What's your favorite class? Or, hey, what do you like to do after school? Oh, I love football. I love music too. Cool. So it's a little bit easier to kind of turn the conversation around in my experience with kids of like, yeah, let's talk about soccer. It's so great. So yeah, those are my quick tips on SIJS. And now we can move on to use teas and VAWA, if you don't mind, Sandy.
Sure. And so, as happens when we're talking about all this really great stuff, the time just goes by so fast. So I'm just going to breeze through VAWA, T's, and U's. So with the U visa, we want to make sure that when we're screening, that goes back to what we talked about at the beginning, that we're not necessarily going too deep, but asking in a lot of different ways. I felt that that's really helpful to ask, have they had any situation where they've had to call the police because they have been in a situation where they feel scared or they feel threatened, or have they been involved with reporting something to the police. And so if they've been a survivor of any sort of crime, and I go into the different types of qualifying crimes, where that could be domestic violence is the most common, but it could be felonious assault, it could be blackmail, extortion, obstruction of justice, tampering. There's a lot of different ones. Um, and I try to also make sure that they understand that it's usually when it's harm to themselves, not so much if their house gets broken into when they're not home, or if their car gets stolen when they're not in the vehicle. Damage to property is not the same as damage to an individual or harm to an individual. And so I asked them if there's ever been, a situation where there's a protection order, or even something that happened to them that they didn't necessarily report. There's different ways where if they have been in a situation of harassment, stalking, but they never took that extra step, that depending on when it happened, that there may be a possibility that they can report it. I've been in situations where a potential client can report childhood abuse later on, depending on where you live, depending on the statute of limitations. Those are possibilities. Or put a protection order if they're currently feeling that they are in harm or that their safety is compromised. And also, beyond the qualifying crime, they have to have suffered some substantial physical or mental harm or abuse. And then they also have to be helpful in the investigation, ongoing investigation or prosecution. That can also be something where they can maybe be afraid because of the domestic violence situation, afraid to cooperate with police because police are scary. And so what we sometimes do is that we can supplement a U visa certification request with a psych evaluation, or breaking it down to police as to what is the cycle of abuse and harm, and how sometimes folks can go back to their abuser because of financial or emotional reasons. And so sometimes if you don't have a very straightforward U visa situation, there are ways that, if that's your area or specialty, or you can refer out where you can, maybe it's not exactly where it needs to be, but if some things change, or if they supplement information to the police, that person can then actually kind of get that form of relief. VAWA is different, where if you're married to a legal permanent resident or to a U.S. citizen, that one you don't need to have a police report, so it's a little bit more broad in what kind of harm is suffered. There's emotional, verbal, and those types of harms for VAWA. And then for T, that can be someone that was attempted to be trafficked, either human trafficking, labor trafficking, or sexual trafficking. There's a lot of broad range in terms of what kind of trafficking. But if there was a situation like that, they can also be you can try to get a T visa certification as well. Those in my time in practicing have become a little bit more common now. Agencies are understanding a little bit more as to what the trafficking guidelines, so that can be also another form of relief. Of course, there's a long wait list. If you're able to get it certification for a U or a T, they do have to wait quite a while. So I also tell my clients that it could be 6 years before they have U visa status, another 3 or 4 years before they can apply for legal permanent residence. So just things to consider. And they can also include derivatives. If they're under 21, they can include parents. If they're under 16, they can include siblings as well, or under 18, I'm sorry. And so there's different ways where maybe the family can come in into those forms of relief. So that's also things to consider. If the U visa is with their abuser, they can include their abuser obviously in the form of relief, but that's also something to flag and to consider in the screening. And I will send it back to you, Emily or Vanessa, for the next part.
All right. I think that to be as brief as possible, and especially since we're really just focused on the screenings, I would say that it's important for us to not make assumptions about what our client knows. And so oftentimes we would say, well, if this person has been here for X amount of time, they probably know or should have known that they could have qualified for X relief, but because they didn't apply for that, then that means that they knew and they just didn't want to, or they didn't qualify. And that's not always the truth. And the reason I really enjoy doing immigration screenings out in the community is because you always almost find 10% of the folks that you saw that day have something available to them that they may not have been aware about. So, for example, TPS is a great one and one of my favorites because sometimes, depending on where the person has been living, where they get their information from, they may not have an awareness that they qualify for something called TPS. They may not know that they qualify for any of the forms of relief that have been mentioned. And so it's really important as you're doing these screenings to ask all the questions. And obviously, if the person has not been here more than 3 days, probably don't qualify for TPS, right? I mean, as it stands in this moment. But do they qualify for something else? And instead of making those assumptions about what we think they would have done if they did, it's really important for us to be mindful in asking all of those questions. I know that earlier somebody had asked the question around, if you don't know, if you aren't sure, right, of their immigration history, would you do all of these different FOIAs? I do all of these for, if it was my mama, I would do all the FOIAs. All right. And I'm pretty sure I know her. I'm pretty sure me and that lady have enough of a rapport for me to say, I know how you came and I know what steps you took. However, you can never be too sure, especially with immigration. How many times have you done a FOIA and discovered somebody's dad was a US citizen, but your client just had no idea? And so there are so many different things that we need to be looking at. But if we're making assumptions that, oh, you know what, we know this, or the client knows this and or should have known and would have acted on it, then we'll always be missing out on some of those folks. There's an entire human being I had when I was working in the detain setting. She was sitting in there. I mean, she was there for months. I'm not sure what led me to go and look into either a FOIA, and we expedited it, of course. And then I'm like, my God, a US citizen, you all are detaining a US citizen in here. And like, and those are the things that if we're missing out on, folks, because we're not looking at these things. We're not taking our time to do it. We're making assumptions that the United States government could never make that mistake, but they do. And so it's so important for us to look at these things. And in the interest of time, I won't go too deep, but it's the same thing. And I think Sandy's going to talk about it, family-based immigration. Oftentimes we don't know who we have that's about to turn 21, or who we have that is able to petition for this person. So ask all the questions.
Yeah, so just to briefly touch on family-based immigration, I ask um, if they have any relatives, and we start from what's your mom and dad, aunts, uncles, cousins, because there's the 245I, I just recently had a client that I've been renewing her DACA for like 5 or 6 years, and she said, "Hey, what's this?" And then she sent me, an approved 245I from her uncle to her mom. And she's unmarried, and we're going to be doing, her as a derivative beneficiary. And it's just one of those things where it's just like, oh yeah, we were cleaning out our closet and we found this. And so at the time, when we did my initial screening, we didn't know that. And she's like, no, I know, I think maybe, but who knows? And we don't know. And since it wasn't for her either, and she wasn't sure which uncle or aunt did it, it was hard to do a FOIA at that time. But ultimately, what I suggest is, as Vanessa said, you want to dig deep, even though you think and this could be with clients, just ask them, and also the FOIAs are your best friends, because that's going to show something that is going to potentially be beneficial, or it could be harmful to the case. So you want to make sure on both sides you're covered. And so also, as Vanessa mentioned, kids turning, when kids are turning 21, if they entered, depending what the manner of entry is, folks can qualify for a waiver, or also if they can qualify for, if they're going to get married, they're thinking like, well, I'm not sure if I'm going to get married, but we're thinking about it maybe in 2 or 3 years. If potentially that's a benefit that can help them, that's what we suggest. Making sure it's a bona fide marriage. I want to always say, don't get married for that benefit. And that's something that, is a very personal thing, but these are the forms of relief that could be attached to that. And so it's very, very important to just make sure that you're doing very full and thorough screenings, because there could be definitely a potential for a family-based form of relief. I-130s that are just kind of stale, that are going to become current, all of that can really, really help in the long run. That's helped with clients that have been in asylum proceedings, and then they have a kid turning 21 and they were paroled in. So manner of entry is very, very important. I know a lot of y'all attorneys are more seasoned in this, but just making sure that you're also not having them apply for something and doing a counselor processing situation where they will not benefit or qualify for that. And, I've heard of situations where folks get stuck outside of the country in counselor processing because they were misinformed. So before you go through something like that, just making sure you're doing a lot of your screening and, making sure what are the different forms of inadmissibility. And we can do a whole presentation on, the permanent bar and unlawful presence and all of that. But those are definitely things to consider and really, really screen for in great detail, so that you're not putting someone in harm's way, or qualifying or trying to apply for a benefit that they're ultimately not going to get into. We don't have a lot of time to cover, but there's also parole in place if folks have family members that are in the military as well. That could be another form of family-based relief. I think that that's a great option if, we have, if you're screening and their children are U.S. citizens, but they maybe not qualify for the family-based petition, but they can do a parole in place first and then do the family petition. That's very, very important to do together as well. So that could be a potential form of relief and something to consider. There's also different humanitarian things that I've tried, or stays of removal if someone has an outstanding removal order. Things are a little bit better, I would say, locally and nationally, in terms of going into a ICE office and filing a stay of removal now, where folks can get an order of supervision, potentially a work permit from that. So those are things to consider also as well, that kind of can go under the umbrella of when you're screening for forms of relief.
Great, thank you. And as a quick reminder, all attendees can submit questions via the Q&A feature on the webinar interface. Before we jump into questions, I just want to encourage everyone here today to use their new skills that they learned from Vanessa and Sandy to potentially take on a pro bono case from our Pro Bono Matters for Families Facing Deportation platform, and I will link it below, and we can move on to questions. The first question is it important to schedule the follow-up with the client at the end of the first appointment, or reach out to them at a better time?
I would say that you have to do a mix of both. So I always like to ask the question, if there's like a more comfortable time to reach you. Is there a time when you feel it's safest to reach you? I don't like to pin people down on an appointment necessarily. And of course, you can gauge the situation. It depends on who they came with and all of that, because I don't want to give anyone else anticipation of when they're getting there. Sometimes your clients may be able to make alternative arrangements to get to you. That does not involve the person that brought them there the first time. So I always like to ask if there's a better time to reach out. I don't like to do a cold call unless the person tells me that this is my cell phone. I'm the only one who picks it up. And of course, it's important to ask whether it's safe to leave a voicemail message, or if it's safe to leave a voicemail message, but I'm supposed to use coded language. And so I'll let my clients know, hey, I may leave a voicemail message asking for something very basic, right? Hey, I needed to confirm what your address was. That may not be really what I need, but they know that they'll call me, they'll be able to figure out how to call me back, and then we'll be able to communicate at that time about whatever it is that I needed. So I would say that, gauge it, talk to them, see, do you mind if I give you a call back this week? Does any day work best for you? Is it safest? Would you rather call me when I know that you'll be at work? Anything like that to kind of gauge what would be best for them.
And the next question, how do you approach SIJS conversations when the family group comes to you together as a family unit to avoid conflicts of interest because they will not be able to petition for a parent? Um, and I imagine that the situation is they came as a family unit, and it's the good parent is in the conversation, and the child is there, so the bad parent is not present. Um, and in my experience, I still explain SIJS and explain exactly as you mentioned that unfortunately with SIJS, the child can never petition for either parent, not when they're at any point in the stage when they're US citizens, it won't matter. They still cannot petition. And I don't ask for any. I say, think on it. This is not something you need to decide right now, but I just want to lay out all of the options because it's important to me that you understand all of the options and you can ask any questions you have, and so that I can help you make an informed decision on what is best for your family, and just try to give them as much agency in such kind of a difficult situation as possible. Next question is, um, any ideas on how to deal with non-responsive FOIAs? Lately, the FOIAs have been unresponsive or records do not address what I was seeking. Any tips?
I cannot believe that the FOIA was not responsive. That's crazy. That almost never happens. Um, you know, with FOIAs, I do think that, filing the appeals is extremely important. And at a certain point, I think you do have to try and involve the ombudsman's office, assuming that you're not able to get anywhere. um, for me, that would be the best bet if ultimately we're not reaching what we need to, and in the interest of time, we actually have to get these records for whatever reason, and really articulating the harm that's going to be done if you don't get these records, right? So I think it's important to take it up, to escalate it as much as possible, including going to the ombudsman's office if you must.
I would
Great,
agree,
thank
and
you.
I would just give, oh, sorry, a pitch for the ombudsman because they have been lifesavers in situations where we would just not be able to get things moved for FOIA or for other issues. I was a non-believer. I am a believer. I have a lot of faith. They are very responsive. They have, I don't know how many people working there around the clock to get things responded to. And so usually when I am at the tail end, because they do want you to document and to show how you've made different efforts to get things addressed, but they will be kind of just that additional like squeaky wheel kind of thing that you need to kick a case up. And if you are under a timeline, let's say to respond to an RFE or to anything like that, or your client is in removal or detention, they are very, very aware of those timelines too. So I just can't say enough good things about the ombudsman. They've been doing a really great job lately.
Great, thank you. Any tips for an intake where de-escalation might be a good use of time?
Do you mean if there's a conflict in the intake?
No, just maybe if somebody's getting a little heated, maybe there's no viable form of relief, and so they're getting a little upset and just trying to de-escalate the situation. No safety concerns or anything, just somebody who's getting understandably very upset.
Yeah, I mean, I always remind people that I'm actually an immigration attorney who tries to defend folks and tries to find these solutions. And so that if I'm not finding them, it's because one does not exist. But they're always welcome to get a second opinion, maybe from someone else, because I never want people to feel like they didn't have that option available to them as well. And that's why I also believe in just education around this, like during your intakes, finding ways to quickly educate folks around immigration, because it's always so easy to say, my cousin did this and my friend did that and I heard this, and they heard it from non-attorneys, but that is the word of God. And so, really trying to do some education around the fact that though the story may seem similar, it is not always similar, and you're always welcome to get a second opinion. I'm not your enemy here. I actually want to help you. It would be beneficial to me to be able to help you. However, unfortunately, there's nothing, and I don't want to lie to you, and I also don't want to do anything, right, that can put you in further harm.
Great. Thank you so much. That is unfortunately all the time we have today. Please stay connected for instructions to get your CLE certification and wait for the evaluation to appear on your screen. To our faculty for this program, Sandy and Vanessa, thank you so much for sharing all of your expertise and wonderful insight. And on behalf of the ABA, I am Emily McCabe, thanking you all for joining us today. And I will now turn it over to Donna for some additional info.
Thank you very much. On behalf of the American Bar Association and the ABA, and the American Bar Association, the ABA Commission on Immigration, thank you for participating in this program. To learn more about our sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.